Wonderful to have a nice showing of folks, and thank you for spending time with us. My name is Leah Wing, and I'm the director of the National Center for Technology and Dispute Resolution. And this is the beginning of the 27th annual Online Dispute Resolution Cyberweek Conference. We're excited to have an incredibly packed and rich schedule every single day. Hope you can join us for some other wonderful events. We'll talk some about that at the end of this hour, but I'm going to turn it over now to my colleague Dan.
Thank you, Leah. Well, again, thanks for all you guys showing up. We appreciate it. And I'm going to do a quick share of my screen just to get us rolling here. I assume that you can see that. Um, so, what is ODR? And why are we starting off with this panel? Um, why do we need this discussion at all? Most people would say, well, I kind of know what that is. But recently, I had an experience that sort of convinced me that not everybody does know what ODR is. I'm on a commission here in the state of Virginia where my home is. And when we first started talking about integrating some issues related to artificial intelligence into the ethics and standards of practice for mediators, it became very clear that the people who were in that session with me were operating on a definition of ODR that essentially was very narrow. I mean, their notion of ODR was that it has to be all online, that it does away with the mediator, and that it's essentially a cradle to grave sort of thing. And that's not exactly where most of us are, I don't think, when we think about ODR. So we thought about doing this, what is ODR, just to sort of take a walk down memory lane about where we got to where we are in terms of thinking about ODR. So I'm going to do that for just a few minutes, and then Leah's going to talk about a rather more thoughtful way to look at the spectrum of ODR. But I just want to get started with thinking about, where did it come from? When we say ODR, what do we mean, and where did it come from? Let me get this moving. I can. Um, the the need for ODR, the beginnings of online dispute resolution actually can be traced back to before there were any online dispute resolution technologies roaming around. And that's in 1992, the National Science Foundation lifted the ban on commerce on the internet. And that immediately did a couple of things. One is it opened up all sorts of uses that created conflict. And it also created conflict that was different from the kind of conflict that we had had before. That really stressed the ability of traditional dispute making methods to handle the kind of disputes that are being created. In 1992, they lifted the ban on commerce on the internet. And by the end of that decade, just using eBay as the poster child, if eBay had been a nation, it would have been the fourth largest nation in the world. And so things grew very rapidly. And importantly for ODR, when you talk about technology and online technology, you do get the ability to use that to resolve disputes. But as Ethan Katz said back in the day, uh, if you think that technology can help you resolve disputes, it can help you create many more disputes. And so that's kind of what happened when the National Science Foundation lifted the ban in '92. We sowed the seeds for needing online dispute resolution. The first use of the term online dispute resolution and ODR that I know of, and I think I'm right about this, was in 1996 with the National Center for Automated Information Research Conference in Washington, D.C. And essentially, it was a way to acknowledge the fact that we were, as a result of the opening up of the internet, creating a different kind of conflict that was very difficult to deal with traditional means. So starting in '96, we have the term online dispute resolution, and it's fair to say that the original use of the term did really pretty much point toward an online system that was sort of cradle to grave, which I'll talk about in a moment. In '97, development of the notion of ODR seriously begins. In '97, UMass Amherst and the National Mediation Board were doing things separately. At UMass Amherst in '97, they began a research project that eventually led to what happened at eBay, uh, run by Ethan Cash, Janet Rifkin, and Leah Wing was there as well. And so that's going on one side, and that's really is looking at how do we deal with this this massive number of disputes that we're creating in a way that is not traditional, in a way that uses online tools. At the same time, in the same year, I went to the National Mediation Board. And I went to the board because they were looking for somebody who knew something about mediation and who knew something about mediation. And frankly, there were very few of us on the ground at the time. And so at this point, we weren't really talking to each other very much at all. And UMass Amherst was doing its thing, and I was doing my thing at the National Mediation Board. Pardon me. In 2001, the first book about online dispute resolution was published. Ethan Cash and Janet Rifkin published Online Dispute Resolution: Resolving Conflicts in Cyberspace. And importantly, in that book, they introduced a term that has had various meanings to various people over the years. They introduced the notion of the fourth party. Now, the fourth party, when they introduced it, really referred to a universe of technology that was moving toward sort of, again, a cradle to grave handling of mediation online. But there's another view of the fourth party that was contemporary, and which Ethan and I think agree is accurate, and that is that the use of technology doesn't have to replace a mediator in the mediator process. In fact, the most common use of technology in online dispute resolution is an adjunct to what the mediator does. And in fact, in my case, when I was working with the board, was an adjunct to very complicated face-to-face interaction, using technology as an aid to those cases, but not taking the place of the parties, not taking the place of the third party, and not taking the place of face-to-face interaction. I put 2001 up here because that's about the time some of the first serious online dispute resolution technologies for mediators, not for e-commerce, were developed, and they were done by Graham in the UK. We Can Settle in the mediation room. Graham Ross and his cohorts created both of those around 2001. And they are designed not to replace the mediator, but to be tools the mediator can use in the pursuit of its regular work. From 2000 to 2010, eBay began developing what we'd call the poster child for mediator-free ODR. By 2010, they're doing 60 million disputes a year. And what's happening with ODR in this period is there's almost a bifurcation. You have e-commerce, and basically now every e-commerce site has some kind of online dispute resolution program. You have that approach to online dispute resolution being moved over into the courts, basically because both e-commerce and the courts are relatively bound universes. There are only so many things that can go wrong, only so many things you can do to correct it. There are laws and regulations in place about how you can work. So it's almost made for a media, or I'm sorry, a technology system that takes over some of the aspects that mediators would do. So that's developing at eBay. Around the same period of time, again at UMass Amherst, the National Mediation Board and UMass Amherst were doing groundbreaking research in the impact of technology on mediation from 2004 to 2010. We started off with the assumption that we weren't talking about, again, that whole notion of cradle to grave e-commerce like ODR. We were talking about ODR that was intended to augment the mediation process for mediators. We started out by inviting mediators into the process and saying, what do you do? And they gave us an answer to that question, and we tried to put a map of mediation up. And then we invited in another set of mediators and said, is this what you do? And they said, well, yeah, mostly, but sometimes we do this instead of that, et cetera. We went through several iterations of this. And finally, what we came up with as the basis, the ground for our research was creating something called STORM, which was a brainstorming application which could be applied to various pieces of the mediation process. And I would consider that work very successful, as a matter of fact. In 2000, well, I'm skip ahead, sorry. In 2014, I published something in the International Journal of Online Dispute Resolution we're offered the notion that the definition of ODR is simply the intelligent application of ICT to any of the processes that make up the universe of conflict engagement practice. Um, I still operate with that definition. Any of the fundamental functions that we do as a mediator, if those are done using technology, I think you belong in the ODR tent. In 2022, the American Bar Association published their guidelines for standards of practice for mediators using technology, and they basically use the same definition: technology facilitating or performing any central function of preventing or resolving disputes. So I guess the bottom line in all this is that even though some of my colleagues were under the impression that when we use the term ODR, we're talking about what is essentially an e-commerce application of cradle to grave, replacing the mediator, doing all of the functions of mediation online. In my view, anyway, and I think in the view of most of the people that I work with in online dispute resolution, if you're using technology, which you undoubtedly are in this world, then you're in the ODR tent. If you're using it to do any of the things that you do as a mediator, whether that's communicating by telephone or video or document sharing, or whatever it happens to be. If you're using technology to help you do some of the things you do as a mediator, you're doing ODR. So, Leah, I will stop there and turn it back over to you. Pardon me. And I know that you have a spectrum that you want to talk about that I think matches fairly well with what I was talking about.
Hopefully, they'll build directly on that, Dan. Thank you. So where I'll pick up here is to share about a document that's available. I can put it in the chat at the end of the presentation, and also you can find it on odr.info, which is the center website, and give a little bit more instructions on that in a moment. But it's an overview of the attempt by the center a handful of years ago to help frame the parameters of what ODR is in both a visual form and also in a descriptive, not a prescriptive form. So picking up where Dan dropped us off, if we think about the kinds of technology that we may use in different parts of our life that just seamlessly have become part of arbitration, court engagement, all the engagement that happens in the shadow of the courthouse regarding negotiation or settlement, mediation, facilitation, and other forms of dispute resolution, even restorative justice, for example. We've seamlessly integrated. Once we got email, as was mentioned before, it became an opportunity to communicate, to be more efficient, and in a space where humans go, then therefore, as Dan mentioned, Janet and Ethan explored the possibility about how conflicts were going to explode in that environment, and also there'll be new opportunities to try to resolve it in that environment. But we all know that technology is not just a location, such as a Zoom room, but it's also a set of tools. And now, over the last 2 decades, more consciously, people have started to think about incorporating technology. And with the unfortunate circumstance of the pandemic, where every form of dispute resolution really to function needed to go online, then video conferencing became, in effect, for many people, required, or the use of WhatsApp and mobile phones in order to communicate, in order to continue the business of relationship healing and problem solving and dispute resolution and increasing access to justice. So if you just glance at these and think about those that you use in your own practice, or if I'm pleased to see we've got students on the call, and I'm sure they're both problem solving in their own lives and thinking about careers in law and dispute resolution, the kinds of technology that they might deploy. We would say, and I agree with Dan and so many in the field, that when we're using technology in a process, whether it's face-to-face or it's entirely online, or there's a section of our process that's online, it can be considered online dispute resolution. Why did we decide to try to create this document? Well, Dan gave a beautiful overview, macro level overview of the history of the development of ODR. And as more and more people started using it, especially with this explosion in the use in e-commerce and then the explosion in the use in other areas, other sectors of labor, environment, family, etc., when the lockdown happened. And then I will say the explosion in the experimentation of using AI came after we created this document, but certainly there are so many more stakeholders in the field who are paying attention to the use of technology. And scholarship and utilization showed that there was a tremendous benefit to increasing access to justice, profit, creative outcomes, but also that technology exacerbated a lot of concerns we had in face-to-face dispute resolution processes, but brand new concerns that had to do with perhaps unequal access to the technology itself or to be familiarity with access. And then when we add AI to concerns around lack of transparency and accountability or any guardrails. And with this, the new stakeholders and new terrain, and with very often really insufficient infrastructure with court policies or funding or the lack of training, and with overwhelmingly a complete dearth of reference to technology in alternative dispute resolution standards, then we saw a growing need to help articulate what the discussion was in the field. And I do want to point towards some wonderful work that Carrie Menkel-Meadow has done when she explored the need for the development of a set of ethics and discussions about ethics in ADR. And she talked about how when a field matures, it ends up leading us to have discussions about what the edges of the field are and who should govern the field and where we should have self-certification or what the ethics are. And so I would argue that ODR matured to the point where that became part of the discussion as well. So here are just four examples of the types of many conversations, both in print and in person, in conferences and online that have been happening. Does a process have to be entirely online to be ODR? And Dan talked about how in his training, sometimes he runs into people who say yes. If I'm employing video conferencing and otherwise I'm doing everything the same as a mediator or arbitrator, is that ODR? Is case management ODR? What about when we use blockchain to prevent disputes over the originality of a contract? Just signing a contract on blockchain, that's actually dispute prevention in many ways. So is that ODR? So the document that we created out of the National Center attempted to point out that how ODR is defined really impacts dispute resolution, both how we envision what the field could be or should be, but also software development. Many of the tools and systems services that I showed you in the graphic at the beginning were developed not for dispute resolution, but like video conferencing, like billing systems, like shared documentation and e-case management. But we employ them in our processes, and increasingly, people have started to craft online dispute resolution provider systems just for ODR. So software development's impacting both the opportunities and also restricting opportunities by the way it's developed. And certainly how we define ODR can and should impact legislation, regulation, education, and the way we deliver our services. So ODR can foster transformation of access to justice rather than merely try to replicate face-to-face with some more efficient tools. And because of AI and because of the ability to engage asynchronistically and cross sectors of society and cross jurisdictions, it offers a breaking down of silos, which also raises new ethical questions. So now I'm going to introduce the framework and just briefly touch upon it and point you to where you can get a copy of it so you can read it more carefully as well. Again, the goal was not to be proscriptive, but to describe the continuum of the discussions in the field of what ODR was. And key to this was what is technology's role within the dispute handling process? What's the level of reliance on technology versus the level of reliance on human actors? And the ODR framework that you're going to see visually in a moment illustrates this through different levels, highlighting the differentiated reliance on humans and technology. But it's not differentiated by the type of technology that's used. So again, the important criteria is the level of reliance on humans as opposed to technology. So level 0 in effect is no technology whatsoever. And I won't say that we could be entirely hard pressed to find that, but it may be becoming increasingly rare when there's zero use of technology whatsoever from the beginning to the end of a process, all the way to the bottom in level 5, where there is no human intervention at all involved and actually unable to be involved. Across the levels, basically ODR level 1 to level 5, technology's impact can be on who can or who must rely on it, the kind of roles that technology or humans play, everywhere from brainstorming, as Dan mentioned, we developed a tool to assist with brainstorming, um, technology used for problem diagnosis, sometimes for attempting to early detect the possibility of a growing dispute, whether the technology is used for decision making, for security, or for administrative functions. And then it also can impact the phase. Maybe we use it for prevention, but then when a dispute arises, we meet in person and we don't use any technology, or we use a different kind of technology than we use for the prevention piece, in order to facilitate, for example, collaborative writing on the same document using technology, even if we're all sitting in the same room together, but we're looking at a screen on the wall, or we're all looking at our own laptops or phones. And then across the levels, again, the amount of human control or lack of control. So let me just briefly give you a couple of examples. As I said before, level 1 is there is absolutely no involvement of technology whatsoever. Excuse me, in level 0. In level 1, this would be a dispute handling process that includes some tech assistance, like real-time video conferencing, or asynchronistic tools that we could use like collaborative writing or document sharing. So here, in this way, the technology does not take actions without direction from the human participant. And you could see that we've got these two columns representing either negotiation, which obviously could have more than just two people, but we have a simple figure there, or we have one in which there is a human third party, and then you can see the gears to represent the fourth party of technology. In level 2, with partially automated dispute handling, then we have independently directed technology platforms that can be employed to process automations, for example. So maybe someone submits an incident and says, I need a mediator, or I need a response to see whether or not my case is appropriate for mediation, just as an example. And then there's an automatic response, right? A level 2 third party process could include a grievance handling system where a user submitting an issue via a form prompts the technology to create a case, conduct an intake, notify all the parties, and assign a mediator. And level 3, human managed technological dispute handling. And here we have fully integrated technological systems that automate many elements, but the third party oversight is required to ensure compliance, to make sure that it's functioning properly. So the tech is supposed to follow all procedural and ethical guidance and offer choices to parties, but humans are considered in the loop because the process cannot be completed without actions being taken by the third party, or if there's no third party, by the parties that are disputing. In level 4, technology-directed dispute handling, has fully integrated tech systems that don't require input from a human third party. But the human third party can influence the process. So, for example, they could step in when if there's a problem with the system, or people say, we now would like the opportunity to have a human engaged and assisting. Um, Either the technology is not working well, or we've reached the end of the assistance that we could use of technology. And this could be, again, it's a human on the loop system. And this may use event or decision tree expert systems or guiding technologies that help point people towards options that can be of assistance to them, but it also can lead to the reduction of options as they make decisions and go through a decision tree, just as an example. And we note that most e-commerce platforms and many filtering ODR technologies are level 4 ODR. Level 5, as of now, we're not aware of one, but this process would be human out of the loop, where a fully integrated tech system does not allow a human to influence the process. So if there's a failure, if there's hallucinations, if the technology is not working properly, humans cannot intervene to change that. If it's working properly, but the humans would like to try something different, the humans are out of the loop. And so it is not possible to intervene in that system. And if, for example, this occurs, we could also say, as we see the speed and the rapidity actually with which AI is being developed, this could be where AI creates AI so that it is a further generation away from even being a human created software that creates a system where humans are out of the loop. So we recognize that ODR in real life is clearly more fluid and multi-directional. And I can't emphasize enough, those levels are not about the beginning of a mediation, the second part of a mediation, the follow-up of a mediation, or the intake of an arbitration, and then a hearing, and then a decision rendered. Those are not what we mean by the levels. The levels are how much reliance is made on the human or on the technology. And so actually you could go easily between multiple levels within the same phase of a dispute resolution process, just as an example. We hope that using the levels can be useful to identify opportunities where people didn't realize, hey, I could use tech here and it would actually increase access or increase efficiency or increase clarity. But it also can help us take a look more carefully at the risks and responsibilities when we increase reliance on tech and decrease reliance on humans. And I do think an argument could be made the other way as well, that when we increase reliance on humans, there are other risks and responsibilities but we're more familiar with talking about them in the field. So lastly, I just want to mention before I turn it back over to Dan, is the fact that, as I said at the beginning, ODR ethics are key to wherever you place the parameters of what ODR is. We hope the ODR framework can assist with decisions about how to set up a system, what type of ODR provider you'd like to work with. And very importantly, if you are going to either take software off the shelf, or if you're running a dispute resolution program, a court or an ADR program, and you want to have a system designed in a boutique way just for your program, what are the questions you would like to ask or the expectations you want to give to the software developers? Because software developers are trained very differently with a different set of requirements, expectations than those that are in the dispute resolution field. And so if the ethics come from within the dispute resolution field, we can be directive and not have the software engineers and the LLM architects be the gatekeepers to justice. So just going to point, they're not going to go over these, but point you towards the National Center for Technology and Dispute Resolution and the International Council for Online Dispute Resolution's ODR standards. And you can find them at odr.info, and icoder.org. Each one of these has one or two paragraphs that are specifically designed to address these issues that are related to specifically incorporating technology into any form of dispute handling. And we updated them in May 2022 to include AI. And I'm happy to share that the International Standards Organization, that has 175 countries, adopted them in March of this year. So with that, I thank you, and I'll turn it over to Dan.
Thank you, Leah. Um, just one quick word, and then with hoping that there is some Q&A that we can have a discussion with everyone. That is, why is it important? Why talk about the definition of ODR at all? For me, the importance of the definition is that for a long time, mediators have used technology without thinking about the fact that it actually has a tremendous impact on the ethics and standards of practice of our profession. Um, if you say okay, ODR, okay, well that's fine. If I'm using ODR, I need to go to these standards over here. There are some ethics that are a little different. I need to pay attention to that. But I'm not using ODR. I'm just using a little technology here and there. I'm just using the telephone. I'm just using email. I'm just using a little document sharing program. The problem is if you don't conceive those as online dispute resolution with a separate set of specialized ethics and standards of practice, then you ignore some of the impact that those things can have. I, for example, argue with the people that I work with that we have to do a risk damage assessment for any technology that we're going to use to exchange information in a mediation or an arbitration. And so we talk about, what is the risk that the information that we're sharing is going to be seen by someone who shouldn't see it, and what's the damage if that happens? That's an ODR question, but it's not a question that gets asked enough for people who don't conceive of themselves operating in an ODR environment. And just as the very basic example, email is awful. It is the easiest thing to misuse. And so if you have something where the damage would be great, and you're thinking about using email because it's so easy to do and because we all use it without thinking about the ethical implications of confidentiality and safety for that information, then you're not doing your job as you ought to do it, in my opinion. You're ignoring some of the ethical requirements and standards of practice because you're not conceiving of what you're doing as an online dispute resolution practice. So that may be a little bit harsh and maybe a little bit in the fringes, but to me, that's why the definition is important, because it forces you to think about what you're doing in a way that is different from the way you think about your purely face-to-face environment. So, any questions, comments, observations, arguments?
Can I just point out, build on that, Dan? I think that in thinking carefully about this, it can really alter one's protocol for what you explain to the participants in advance, or what responsibility you take for making sure they understand the technology, or you don't take that responsibility and you let them know that it's on them. Um, and those are just two really tiny examples, but I think it can alter your practice. And Dan, I wonder if you could just tell the name of your book, because Dan spent quite a lot of time framing some very important questions and describing how technology can be your friend, but we need to think through a variety of things when we're employing it. So Dan, maybe you could just mention your book.
It's called Integrating Technology into Your Dispute Resolution Practice, because you've got to have a colon, making friends with the fourth party. And it's available, should be on Amazon, easily findable. Any questions or comments from anybody who's joined us? Hello, Ethan. You're on mute. Have we done damage to your legacy?
Move beyond anything I'm responsible for. But if I can add a sentence or two to what you explained so clearly and so visually, um, I had the benefit of having a colleague, Janet Rifkin, whose field was ADR. And my background is not as, I'm not a trained mediator. I learned everything I know about mediation from Janet, but our collaboration was fortuitous, and fortuitous in the sense that we both could talk to each other, and we were talking to each other in ways that others weren't. And they were talking to each other in ways that were obvious to us, but for 20 years weren't obvious to anybody else. So I'm enormously overjoyed at the fact that we have an international group here talking about this issue this morning. I'll say one other personal thing. I like, I think the field is moving towards taking seriously the level 5. And we don't really know what the ramifications are all too that are embedded in the use of technology, solely use of technology. So, Cyberweek, I think we'll spend most of our time on level 5. Anyway,
Well,
thanks, Dan and Leah.
yeah,
Wonderful session.
thank you. Yeah, the way I phrase it, Ethan, is that until COVID, we were all crazy, the ones of us who were dealing with ODR. And when COVID hit, all of a sudden we weren't quite so crazy. That not only could it could work quite well. But I also agree with you about where we're going, and we're going there fast, and it's kind of scary in some ways because we're getting development that is faster than our ability to talk about the development and integrate the development.
I would also say one thing I've begun to notice, and I'm pondering this out loud, I guess, for the first time with colleagues here, is it seems like there is a parallel track of attention to tech and access to justice, tech and the law, and that unfortunately silos have begun to develop a little bit in the broader field of dispute handling, whether it's the justice systems or ADR. And so I think the description and the explanation of what ODR is, how it originated, and what it actually reflects is helpful. So that more people who are thinking about employing technology to court or to helping clients prepare for court are not often, as much as we would hope, paying attention to what ODR ethics are or the work in ODR. And so the more we can bridge the gap, the better. And so hopefully something like this framework is useful. And also all of you are now ambassadors to helping bridge that gap. And I again open it up. Comments and questions to those that have participated.
Yeah, please, anyone, just speak up.
Hey everyone, can you hear me?
Yeah,
Hi guys. Thanks so much, for this. This is very helpful. This document, the framework of level 1 through 5. I would hope that level 5 is not going to be here that soon, only because I think you used the word scary, Dan. The possibility of folks just having AI drive things could potentially be a recipe for disaster. I'm pretty sure the state bars will step in and do something about that before we ever get there, I would assume. But for where we are right now, just look at the spectrum from 0 to 5. I would think that we are a solid number 2, partially automated dispute handling. I think most people are still stuck at 1, but I do see us moving towards level 2. No, pretty quickly. And I will also add that what Leah says is correct about silos being created. My thing is always how do you get this to the masses and popularize, ADR and ODR. And I always think that online mediation within the ODR bubble, online mediation is the key because unlike all the other things, online mediation is where regular people meet every day to resolve the disputes all around the world. for common problems, so like family law, which I do. But when you get into arbitration and the courts, a lot of that you need funding, or a lot of that you need, there are certain gatekeepers that are already in place. But online mediation, though, I think you can't really, dispute the fact that that's where most everyday people are by the millions. And so I think if energy and attention is focused on that, then it could probably spill over to bring more attention to the rest of it.
Well, I'll tell you why I have some trepidation about the future. And it has not to do with mediators and dispute resolvers. It has to do with technologists. The history of the development of technology suggests that if something can be done, it probably will be done. And the question about whether we should be doing it is a secondary question, particularly in an environment like the AI environment that we have now, where everyone's chasing the money. And so I don't see a lot of deep reflection in the development process for technology. And so what that says to me is that the dispute resolution community should make an effort to have a loud voice in saying, this is what ethical stuff looks like. This is what it looks like to create something that operates well in our environment. We should be saying that very loud. Because if we're not saying that very loud, the technology is going to be developed anyway. And we're going to be recipients of whatever's out there as opposed to saying, hey, we can guide this a little bit. So that's my trepidation.
I'm building on what you all are talking about. I do want to point out that level 5 describes what human out of the loop would be. But if you go to the ODR ethics that the center and ICODER put out and that the International Standards Organization just approved, it says that that's unacceptable. So it places a guardrail, and I think it is rather astounding and formidable that you have 175 nations standards bodies that belong to the ISO, and the ISO, after 3.5, almost 4 years of negotiation, made a decision to say that that's not to be acceptable. And this is for e-commerce. Their ISO standard 32122 that they passed in March is specifically for ODR providers for e-commerce. But I think that whether people are self-certifying, whether organizations are making decisions, whether the marketplace is making a decision, whether our international and national bodies and entities are making a decision about governance really makes a difference. And kind of speaking to what Dan said, well-intentioned and leaving things to the marketplace can make lots of things flourish, including bad actors and blockages to access to justice without any kind of regulation or commitment to having humans in the loop, or at least on the loop.
You know, Hi everyone. Picking up on something that you mentioned earlier, Leah, about the role of ODR in dispute prevention. I would say that, and especially since, I was just looking at an old Wired magazine, which was called The New Internet. We're there again with the blockchain. It's a new operating system. And as was the case back in the day, I would include mediators, whether they're lawyers or not, in this. We're generally behind the curve in any of this adoption. And the other aspect of it is what's the role of the courts going to be? Because the dispute resolution community, instead of focusing on the dispute prevention side, really tends to pick up mostly on the dispute resolution side with the courts in the middle of it. And I see the courts under attack everywhere, including the Supreme Court. So the question of where the courts are going to be and the opportunity for the mediation community, which is really a dispute prevention community, to rise up in the dispute prevention mode is where the real opportunity is. And I think you have to look at intergenerational aspects of it too. I think we really have to be thinking about the 20s and the 30s, those kids, and working with them and as often as we can, getting in the school kinds of settings and working in the peer-to-peer kinds of environments and really structuring our relationships there. Because the courts they're just not functioning well. And they're too expensive. Most cases gets resolved. But our community can be focusing on the dispute prevention side of things, which changes the natures of how disputes arise too. Because blockchain is a dispute prevention tool if it's done right. So I think we need to be thinking in those terms as the international community continues to struggle with the fact that the crypto criminals are the ones who are rising up faster than anybody else in this new blockchain space.
So we have a very international crowd here, and we also have a very intergenerational crowd here, since I know that there are people from all different generations on the call. So I just want to welcome questions or comments in the chat, or anyone else who wants to give an opinion on the topic underway or ask a question. Please feel free, or just ponder something that's on your mind. We'd love to hear what you all are thinking.
Anything at all? Well, I don't know if it's the last word or not. I hope it's not, but I'll just say that picking up on some of the things, some of the comments that were just made, is that bad actors are going to act badly no matter what we do. So that's not where my focus has been. My focus has been, if you want to create an environment where the use of technology is ethically applied, where it creates no damage to either party, where you're doing no harm. If that's what you want to do, then the goal should be to create frameworks and create definitions and create approaches that say this is what it ought to look like if we're going to do it well. If we're going to do it without damaging the parties, if we're going to do it without damaging the process, and maybe even improve the process, this is what you do. So I look at it as the notion of definitionally, I look at it as, what is the right way to do it? What is the best way to do it? What should we be doing with the technology as we move forward? Not so much what is the way that we block bad use, because we're never going to block bad use completely, but we might be able to affect, to some degree at least, the development of technology and the use of technology that fits into what we think of as good standards of practice and good ethical use. And so that's kind of one of the reasons why we wanted to do this session is, it's important to talk about what we mean when we say our field. What do we mean when we're talking about that? That's an important element in trying to figure out how we do it right. Any questions, any comments, any final words? Ethan, you got any words of wisdom? You're on mute again.
Brilliant. Thank you.
Thank you.
So
Okay.
with your permission, Dan, can I just share the screen about things for later today?
Oh, sure. I was going to do that early, but yeah, screen's better. Go ahead.
Okay. So y'all, just a couple things. Want to share the screen and just note that next up is going to be a magnificent presentation starting in 12 minutes. AI redefining dispute resolution in Nigeria, with our own fellow Morenike Obi-Ferende and 3 of her colleagues. And then also at 2 o'clock today, we have Jintae Tan from the Cyber Justice Lab. He is a PhD student. I've heard him present already. Very interesting work, very provocative work. I think presenting things that many of us have not thought about yet, about the relationship between AI and mediation. And if he does a similar presentation to the one I saw, it will hopefully be eye-opening. So really want to encourage you to consider attending. We've got several other presentations tomorrow and later in the week where we've got graduate students presenting. And I think it's just wonderful if we can help support the next generation, hear their ideas, which will help stretch and grow our field. And lastly, over the course of the week, we have a wonderful colleague, Noam, who is going to be taking all the videos and then uploading them. So over the spot that says join, it eventually will say view. And so it's a one-man show, and there's a lot of events all week, so it may not happen right away. But if you're interested, if you missed part of this session or you miss another session in the future, eventually all of them will turn into a video. And that is actually up to each of the presenters. So some presenters may not choose to record their session. We can't promise that. But with that, I'd thank everyone and thank Dan.
Well, thank you, Leah. It's always a pleasure to be with all of you. It's a good community.